Okay, who's representing Mr. Lee? Mr. Etheridge representing Mr. Lee.
Your Honor, I met with Mr. Lee a little over a week, maybe 10 days ago. Mr. Lee, is there anything new since I last talked to you that I need to speak with you about before we start sentencing?
Anything new is that I still have an opportunity for that job if I can get out. So
Okay. When you get a chance to speak, you can advise the judge of what job that is, okay?
excuse me.
When you get the chance to speak during sentence, when you get a chance to speak during sentencing, you can tell the judge about that job opportunity, okay?
Okay.
I think we're ready, Your Honor.
On the record in the matter of the people of the state of Michigan versus Dennis Madison Lee, file number 23-03518, counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Good afternoon, Your Honor. Attorney Derek Etheridge, and also the public defender on behalf of Mr. Lee. Your Honor, obviously I'm here physically in the courtroom. Mr. Lee is appearing by Polycom from the Ingham County Jail. That's my understanding. He will waive his right to be here in person for sentencing and ask the court to go forward with sentencing at this time by video.
Today's date set for a sentence. I do not have a prepared pre-sentence report because your client failed to appear.
Correct, Your Honor. I did meet with Mr. Lee regarding his failure to appear around around April 18th. He advised me at that time he had forgot or didn't remember that he had those appointments. I did email the court, I think it was Miss Addie, letting her know that he was in jail and that would be available if they wanted, if probation wanted to meet with you to try to complete a PSI. But obviously, as the court knows, he was a no show, no report for the original PSI date.
You can make allocution.
Thank you, Your Honor. Your Honor, when speaking with Mr. Lee and representing him throughout this, he, from the very beginning, had taken responsibility for his use, possession of meth, ultimately possessing it because he was using it at that time. He appears to have around 12 days of jail credit now. I know he had 1 day jail credit listed in the no-show report. He advised me he was picked up around a few days before the sentencing, I believe, that was scheduled. It appeared based on the information he gave me, he would have about 12 days credit as of today. He does have some bench warrants that he was trying to get taken care of. He said he was only aware of 2. one regarding a not valid license and one that was out of Jackson County that he wasn't exactly sure what it was about, but he knew he had one. Obviously, he probably or should at some point get a substance abuse assessment as part of his probation to see if he needs any treatment or counseling, and to advise me he's open to completing that.
He's open to completing what? I'm just gonna, because at this point, I know, you might need to talk to him. He's gonna be more than open to you. There was a killer brew of no upfront jail, but he's not followed the court's order from the time that he took a plea until now. So he's looking at upfront jail. He's not looking at me chancing it and putting him on probation. I don't have a substance abuse assessment. He was ordered to do those things so that I can know how to properly sentence him today. So he needs to decide if he wants to withdraw his plea or not, because he had a killer brew. And I'm looking to sentence him to upfront jail.
Actually, Honor, he has no right to withdraw his plea because he violated bond after a plea and before sentencing. I've already told him that. He's not here to withdraw his plea.
Okay, well then.
That's my wording is open. He has expressed to me his desire to attend treatment. And that's my understanding that he was, I use the word open, but he's more than willing to participate in any treatment or assessment the court orders as part of his probation.
Okay, I need for your client to decide if he wants to address the court. It's nice to have someone put all these niceties together for him, but that doesn't let me know that he's willing to do what he's supposed to do. He has a history of failing to appear and a history of not following the court order. And then he has a pretty lengthy criminal history. And so it's good for your attorney to come in here and say, oh, he's like to do X, Y, and Z. I need to hear from him.
Mr. Lee, could you express to the court your desire about seeking treatment?
Yes, I think that is a seek treatment, and I want to apologize for not showing up for the last court. I had issues with my medication, and I showed up. It was a day late. I showed up the following day. I misunderstood or had that mixed up in my dates. I showed up on the 17th. I think the day I was supposed to be in court was the 16th or something like that. I think I showed up the day after.
Correct. We addressed that. Are you talking about February? Are you talking about February? Because we addressed. Are you talking about when you showed up late on February 16th?
Yes.
Okay, I'm talking about your order to report to probation so that you can get prepared for a sentencing date. That's what I'm talking about.
Okay, well, when I showed up when I left the court that day, I think it was on the 5th floor or something like that. I went to the 5th floor and talked to someone, and they gave me paperwork, and I'm told to come back, and when I came back, she said that I had not been assigned to someone at work or somebody was supposed to do some type of something with me, and I didn't know, so I never went back after that. I was supposed to call her back and file money, but I got arrested before I could do that.
Okay, so this is one of the many issues that I have with the statement that you're giving. That's why I wanted you to address the court, and not necessarily your attorney, because when you were here for your plea, I told you that you had to undergo a substance abuse assessment. I said that out of my mouth to you. Did you do that?
But where was I supposed to do that?
No, did you do that?
No, where was I supposed to do it?
Did you find out where you were supposed to do it?
I went to the 5th floor. I thought that's what you told me to do.
I told you to go when you left here. That was another instruction. I said, you need to leave here. You're going down to the 5th floor to check in with probation so they can get you set up for a pre-sentence interview, and that you would have to undergo a substance abuse assessment. Our probation agent, particularly the one that you met with, has been here for over 15 years. She's not new to this. She scheduled you and advised you that you needed to have a substance abuse assessment. You did not return on your appointed time.
I didn't know the appointment time, and I must not understand that. I must have misunderstood the appointment time, because when I did make contact with them, I went there when you told me to that every day. And when I left there, I didn't have one, but she said, they'll hold her within a week. I got a hold of that lady and she told me that there was no one assigned to me to get a hold of her that following Monday.
It says here, Mr. Lee was provided all the instructions for him to appear for a substance abuse assessment and for his appointment date and time in writing before leaving the probation office. He failed to appear for the scheduled appointment and has not provided a completed substance abuse assessment.
I understand that. So it must have been a misunderstanding on my part. So when she told me to call her, come, she told me that I hadn't been assigned to a worker, whoever that is.
He was instructed. Mr. Lee was instructed to obtain a substance abuse assessment and provide it to the court no later than April 4th. He was provided instructions for this as well as an appointment date in writing. You didn't do either. You didn't report for your appointment with probation so they can do the interview. You didn't go get you a substance abuse assessment and tender it to the court. That was your responsibility. You're responsible for any miscommunication. There was no miscommunication from probation. There was no miscommunication from your attorney. There was no miscommunication from the court. You are too old for you to sit here. You are too old to sit here and pretend like you don't know what you were supposed to do. You have too lengthy of a criminal history for me to believe that you don't know what you're supposed to do now. You should be explaining to your attorney what's next at this point. That's what your criminal history reflects. And you think I'm gonna put you on probation so I can have to babysit you for 6 to 9 months? Is that what you think? You think I want to put you on probation so I have to babysit you for the next 6 to 9 months and continuously remind you of court orders?
No.
Well, what things have you done to demonstrate to the court that you know how to follow my orders?
Like I said, it must have been me not hearing and understanding what she had said to me. That is my fault. I'm not taking any responsibility of my own or blaming you or the court for something I was supposed to do. I'm not doing it. That's my fault. I'm taking my responsibility for that. And I'm sorry for that. I mean, I'm not trying to get out of this. I did whatever I did. It's my responsibility.
Okay, and you have a job lined up, is what I hear?
I'm willing to do whatever it is I need to do to get this over with so I can go on with my life.
You have a job lined up? Yep. Sir, can you hear me talking?
Mr. Lee, don't talk over the judge. Let the judge speak.
Do you have a job lined up?
Yes, I do.
Where?
He don't tell. It's inside.
Say it again.
Excuse me?
Repeat that because it's not clearly coming through our polycom.
It's called Ito Chef.
Okay.
It's inside our Horrocks.
Inside Horrocks?
Yes, ma'am.
And when are you supposed to start?
I was supposed to start on the 16th of this month, but I have been in touch with them since then, and I still have the job around me. And my apologies for speaking over you. I didn't know I was doing that.
It likely was a polycom issue because you're not even coming through clearly. That's why I'm struggling to understand what you're saying. Are you followed up and you know that you still have a job scheduled there or lined up there?
I do have a job lined up.
And when will you start?
As soon as I can get it. They said.
What are you going to be doing there?
I'm a cook, I'm a chef by trade, man.
Is he being held on anything else?
He has 4 warrants on it. I don't know if those have been taken care of.
Did you get your other 4 warrants taken care of?
One report here, I'm working on it right now. One is in Jackson.
I didn't ask you where any of the warrants were, did I?
No, ma'am.
What was my question?
Am I getting them taken care of?
I said, did you get them taken care of? Have they been taken care of?
No.
I'm trying to see if these are for this one. I don't know if this is in here inaccurately or not. Let's see. Okay, the concern I have, Mr. Etheridge, is I don't think your client's going to return back here after getting all this taken care of. I see things pending in St. Clair. Not so concerned with the traffic offense, but there's a one theft that he has a bench warrant for. I wouldn't say bench, he has a warrant, it says here, for felony for vehicle theft. And then he has some traffic matters ready to appear. And I need an assessment. I don't know how, I don't even know how to sentence him because he didn't follow the orders. My only option is to remand him so that he can have a substance abuse assessment done by our probation office and they can complete his PSI. Then I'll issue or give him a bond so that he can address these other warrants. I'm not releasing him to another county without getting my work done on my file though. Let's see here. That's the only thing that I see pending that I just stated there.
Understood, Your Honor. So we adjourn sentencing to another date so that the court can have probation complete really for our report.
Yes, I'm gonna note here, he's in Ingham County Jail. He'll be assessed from Ingham County Jail by one of our probation officers. And a new PSI can be produced, or a complete PSI, I should say, can be produced, and we'll reset the sentencing. I'll note here, court will address bond after he's been assessed. Sentencing June 28th at 9. June 28th at 9 is the new sentence date.
Thank you, Your Honor.
You have any questions today, Mr. Lee?
I just don't know what just happened because I can't really hear you that well.
Okay, I'm remanding you to the Ingham County Jail so that our probation department can meet with you. They're going to need to do an assessment so that the court knows how to properly sentence you. And so I'm not going to take a wild stab in the dark as to what programming you may or may not need, or even if you should be on probation. You'll meet with probation. They'll provide the court with the pre-sentence report. And then after you meet with them, your attorney can address bond with the court on your behalf, okay?
Okay.
So this is basically what I told you likely would happen, that this is being rescheduled. I will schedule a polycom with you to go over some stuff in more detail, okay?
Okay.
All right, thank you, sir.
You're all set, Mr. Lee. Thank you, Mr. Etheridge.
Thank you. I'm sorry for any confusion.
You can tell the deputy you're all set.
Okay, I don't know how to do that, deal with things.
They should download so that it's just.
On the record in the matter of the people of the state of Michigan versus Haley Thibodeau. I have here file number 23-01343, and I just received file number 23-03257, council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Attorney Etheridge from the Office of Public Defender on behalf of Ms. Thibodeau. The second file, is that the misdemeanor file, Your Honor?
SM, yes, that's correct.
Your Honor, that is Mr. Lee's file. However, I'll appear for him today since he is not here.
Yeah, she's not been arraigned yet, so
That's a new file.
that's correct. Okay, so I have here a misdemeanor complaint, in file number 23-03257 that you need to be arraigned on. That alleges that on or about September 11, 2023, at the area of 600 East Michigan Ave, City of Lansing, Ingham County, State of Michigan, that you did allegedly, contrary to law, commit the act in count 1 of retail fraud, 3rd degree. The allegations are that you did, while Meyer Capital City Market was open to the public, still property of the store that was offered for sale at a price of less than $200. Now, this is contrary to Michigan compiled law 750.356 D4. That's a misdemeanor. Maximum penalty is 93 days in jail and or $500 in fines, or 3 times the value or difference in the price of the property stolen, obtained, or attempted to be obtained, whichever is greater. To impose a fine of 3 times the value, the defendant must admit the amount, or it must be determined by a trier of fact. Do you understand the charge read there in the maximum penalty, ma'am?
Yeah.
Okay, so you have the right to be represented by counsel. Mr. Etheridge, who's representing you on the other file scheduled for today, is representing you today for the purposes of this arraignment only. You have the right to have an attorney with you to represent you at all of your court appearances during the pendency of this prosecution. And you have the right to have an attorney with you if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can make a request to have the public defender's office appointed at the expense of the public. And I'm assuming based on the representation by public defense in her other matters, she wants it in this matter.
Yes, it is, Your Honor, and I will complete a request form for her and turn it in on her behalf.
Okay, I'll note that here on the file. I also enter a plea of not guilty, but I will advise you that you have the right to plead guilty, plead not guilty, or stand mute. We're entering a plea of not guilty today because you've not even received discovery and you haven't had an opportunity to be advised by counsel on this. Okay, so the court wouldn't even entertain a plea of guilty if that's something you wanted to do today. You have the right to proceed to a trial on this matter, and you have the right to a jury trial. At the time of your trial, you have the right to the presumption of innocence, so you're innocent until proven guilty. You have the right to require the prosecutor prove your guilt at a trial by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to remain silent at trial, not have silence used against you, but you can waive your right to silence at your trial and testify, or you can subpoena witnesses to testify on your own behalf and present evidence that you believe show a defense to the charge being brought against you. Do you have any questions about those rights? Okay, you're scheduled for a pre-trial conference before me. It's going to be May 7th, which is a Tuesday at 9 o'clock in the morning. You must appear in person, okay? Do you have any questions about that at this time? Okay. I just. Okay, now. She's in custody of Clinton County.
Yes, Your Honor.
Where is she being held on?
She
Over there.
is, has pending sentencing, which her sentencing date, May 28th is her sentencing date.
Okay, I'll set her bond in this matter at 1,010%, so that she at least accrues time while she's sitting on that file.
Thank you, Your Honor.
No problem. Okay, and as to the felony, we need an adjournment.
Yes, Your Honor. Your Honor, she is legally and clinically approved for drug court. They do have a opening for her. The drug court, because of, if the court may recall, in her Clinton County case, she was referred for competency and came back competent. And then on one of her scheduled hearing dates, she had some issues at the jail where she wasn't able to appear here. So the prosecution, my understanding, and Ms. Patowski can correct me or state the prosecutor's position, but they want a little more information about her mental health before we actually transfer her to drug court. The goal still is to transfer her to drug court in 54B.
And that's completely accurate. The drug court coordinator, as well as higher ups in our office, just want to confirm that we want to receive the competency report from Clinton County and just confirm that drug court is the right fit, although that is what we believe to be the case. And I spoke with Ms. Thibodeau's Clinton County attorney this afternoon, and he will be sending Mr. Etheridge and I a copy of the competency report sometime next week, is what he said.
Oh.
So we should have that soon and be able to proceed.
Sounds good. So we don't need much of a reset. Okay. We can do May 10. So you're going to be May 9th. May 9th at 9.
That's for another PCC, Your Honor?
Yes, we'll do a PCC.
Yeah, don't. Witnesses to come up with this one end of transfer, which is the goal.
When is her court date on that file?
May 7th for the new misdemeanor.
This is gonna be written. Yeah, we'll do it on the same date just because we have to read her anyways.
And she does have another misdemeanor file with Mr. Lee.
So
Let
it's
me
the
see
7th.
if that's scheduled for
I
anything.
think they're all on the 7th at this point.
They're all on the 7th. Thank you, Your
So
Honor.
we'll do 7 at 9?
Yes.
We'll do May 7th at 9, and that way we're not incurring expenses for the government to keep bringing her over here in the same week.
Thank you, Your Honor. I'll make sure that Mr. Lee is aware as well.
No problem. Do you have any questions today, ma'am? Okay, any additional matters for the record, counsel?
Nothing for the people.
Nothing from the bench, Your Honor. Thank you.
Thank you. You're all set. I didn't realize that Nathaniel was back there, so when I. Speed, Mr. Speed? Okay, Mr. Austin, do you need to speak to your client?
I do not unless he needed to speak with me.
I'm good, Your Honor.
Okay, then we should
On
be
the
ready to proceed.
Thank you. On the record, in the matters of the people of the state of Michigan versus Hakeem Speed, I have file numbers 23-03228 and 23-03301. Appearances for the record.
Prosecutor Petrowski on behalf of the people.
And thank you, Your Honor, and good afternoon. Jared Austin appearing on behalf of Mr. Speed. We are both appearing remotely via video.
Thank you. Okay, I have 2 PSIs, one in each file, indicating that they was prepared on April 9, 2024. council, you got a copy of these?
Yes,
Your
we
Honor.
have received them and I provided copies of each to Mr. Speed for review.
Okay, do we need to make any changes, updates, or corrections?
The only one I would add, Your Honor, is that it was made in contemplation with the original scheduled sentencing date of April 18th, which was adjourned by the court, so he would be entitled to, I think, 8 additional days of jail credit that they have calculated.
Oh, sounds good. Let's see.
No corrections for people.
So should be a total of 177 days, but with that, Your Honor, I had no further corrections or updates.
I'm trying to understand this note. It doesn't make sense. Seems to say his bond is in the system because I haven't heard that he had for some reason they put personal recognizance, but I think he was supposed to be remanded.
And 03228, it does say personal.
PR bond?
Yeah, and 3228.
That's what I have in here too. I'm trying to figure out how they have some accruing credit if he had a PR bond.
3301, no, it's like bond denied.
0-1 bond was denied. Okay, I do see where that was there. That's my question. I have an issue with how they calculated his credit on file number ending in 3228 because the indications in the court record were that he did have a bond. And it was a PR bond.
And that was the case that was first in time. Is that correct, Your Honor?
That is correct.
Yes, I think that was initially correct, but I thought that changed shortly thereafter when he picked up the new file, which was a subsequent violation. And then I thought there was a change in that bond status when that occurred.
I think his bond was revoked in that file on November 2nd of 2023.
Yeah, I see that I checked, he was present in court, but he was intoxicated. And so I could not arraign him. Then he appeared on the 9th. And I'm looking at the bond by the PA 53, the actual PA 53 indicates that there was a PR bond, but that could have been an error. Because my note doesn't say. This was a PA 53 that was prepared by the court staff on December 28th. I don't know who was in here. That would have been somebody assisting.
What, are you
Wait a
talking about
minute.
for the bond?
Yes. To say remand.
It says that. Trying to see.
It should have been a remand. It might just not be in the system, because I think whoever helped our newer court officer, which would have been the second day he started. I think that's the issue on December 28th. You should have been remanded. Okay, the 9th bond revoked. I did revoke the bond on the 9th. Okay, sounds good. Okay, you can make allocution unless there's any other changes.
No, Your Honor, I will just go into allocution and thank you. Your Honor, I think the reports capture Mr. Speed and his circumstances rather well. I certainly think alcohol was a factor in these cases, and maybe to a lesser extent some mental health concerns. But positively speaking, there's a number of things I think I can say for Mr. Speed while he's been incarcerated almost 6 months, serving approximately half of the sentence on these files. At the time of the plea, he purposely did not want me to advocate to the court to have him released on any type of personal recognizance bond because he realized his own struggles and the instability that he had at that point, that may cause him problems. So he has that realization about his own limitations, and I think he recognizes his own struggles. While he's been incarcerated, he informs me that he's put his time to very good use. That at the jail, he's been participating and attending 12-step meetings. He's done restorative justice, as well as substance abuse and anger management, been participating in peer recovery. He has plans upon his release to follow up with CMH, where he'll be engaging in group counseling, and he'll be doing drug screening there. So he has a plan moving forward, I think, to hit the ground running once he is released from incarceration. I'm a little concerned with the lack of, I think, finances and so forth that I think he has now, which may cause him some issues. If the court were to place him on probation, I would ask the court to consider sentencing him to the time that he's already accumulated. If the court is not inclined to do that, then I would ask the court to adopt the recommendations and not to exceed what is being recommended by the probation department. Thank you.
Thank you. And did your client want to make a statement on his own behalf?
Mr. Speed, is there anything you'd like to say to the court before sentencing?
Yes. Just to piggyback what my attorney said, I have been taking the right steps since I've been in here. I was not on the right path when I was out there, self-destructing. Since I've been in here, I've got back in contact with my therapist, my mental health. I've been going into 12-step programs, got me a sponsor, restorative justice, getting in contact with people who are not using. I've just been doing the right things, not wasting my time since I've been in here mentally, physically. I've been working out again, spiritually, back in my faith walk. Just a lot of things I was doing when I was out there that I was just going against natural, what's right, what I know was right. And as you stated, majority of the things that I have planned would be things that would, the probation would be asking of me. I just don't want to, I tend to get overwhelmed. So what I'm saying is I have things in place as far as drug testing, meetings, therapy, counseling, IOP, which is outpatient. And I really built me a circle since I've been here, people who really care about it. And I was just asked that the courts, I asked that the courts fully restore my liberties as a member of this community. Thank you.
Thank you. I'm happy to hear that during the time that you've spent in custody that you have used it for restoration. I think that's good. That's the goal. But you know, you're here and before the court for the original charge, at least as charge is use of methamphetamine. We're talking about something, a serious poison to your body. And the court doesn't want you to get overwhelmed, but the court also doesn't want you to be released. And there's nothing in place that helps to ensure that you have the tools for your longevity of your success with staying away from substances that would harm your body and your ability to function as an upstanding member of this community. And so that is the court's concern. I appreciate you sharing with the court some of the things that you've already put in place so that when you are released that you have some structure, because structure is going to be essential if you're going to be on the right track once you're released from here. But I think that the recommendation from probation, which is that there needs to be some additional court oversight and substance abuse treatment by way of outpatient programming, I think that that's important. So the court is going to adopt the recommendation with modification. And so the recommendation from probation on file number 32-03228 was for a term of 9 months probation. I'm going to amend that to 6 months at this time. While on probation, you'll have the following conditions. You'll need to continue with your mental health counseling at Community Mental Health and provide verification of that.
In jail for 1 year.
And so that means you'll need to sign a release of information so that probation can get that information directly from CMH, okay?
Yes, Your Honor.
Probation will need to find out what medications you're on, and that information can be provided to them as well through CMH.
Yes, Your Honor.
In order that you attend a 12-step meeting as directed by probation, and you'll provide verification of that, okay?
Yes, Your Honor.
You will be required to obtain employment while on probation. And you're not to engage in any assaultive or threatening behavior. You're not to use, purchase, or possess a firearm, ammunition, or weapon of any kind. You're not to possess or use alcohol, marijuana, or any other controlled substance that's not prescribed to you by a medical professional, okay?
Yes, Your Honor.
You'll be required to submit to random preliminary breath testing and urinalysis testing. You are responsible for the cost associated with that. I recognize that you have some other parameters and things that you have set up on the outside. If you are already in a programming that will be testing you, and that's a program that can be sanctioned by the court, you can provide that information to probation so that we're not ordering you to test more than one time, okay?
Yes, Your Honor. And,
Yeah.
with the fees, I don't have, right now, I have a way to pay the fees. I have, opportunity through CMH to screen for free, through my insurance. So, I think that'd be helpful also.
I'm noting that here, because if you're gonna be screening and testing through CMH, I'm not going to order you to do it and incur additional expense. You'll just have to provide, again, a release so that we get that screening information, okay?
Yes, Your Honor.
Okay, now there's a $30 per month oversight fee for each month of probation. I'm ordering you for 6 months, so that's $180 in probation oversight fee. There's a $75 crime victim rights fee plus $50 state minimum cost. There's also a $100 assessment fee that will be assessed. I don't want you to focus too much on those fines and costs right now. Focus on the programming portion of your probation, because at the end of the programming, if you're already doing your testing through CMH because it's paid for by your insurance, and you're already doing the other things that the court has ordered, including you've gotten employment and you've done your mental health counseling in 12 steps, the court can address the fines and costs at the end. I cannot, however, waive the programming portion that I'm ordering you to do, because that's for your well-being, okay?
Yes, Your Honor.
Okay, your total fines and costs of $405. You do have the opportunity to make monthly payments on that, but again, I recognize you're not currently employed and you are indigent, and so the court can address that amount at the end of your probationary term, okay?
Yes, Your Honor.
Do you have any questions for the court about fines and costs or about your probation requirements?
No, Your Honor.
Okay, lastly, there is an advice of rights as to probation. It says you have been sentenced to a term of probation in the 54A District Court. The conditions have been individually tailored and are specific to address your assessed risks and needs, except for domestic violence, criminal sex crimes, stalking offenses, or an offense where the defense of guilty but mentally ill was asserted. You may be eligible for early discharge from probation, and you have the following rights. You have the right to request early discharge from probation once you've completed half the original term ordered by the court, so long as you've not had any violations within the 90 days preceding that request and you've completed all of the required programming. You would make that request by using the court's MC 512 form that's on the court's website, or you can request a copy of the early discharge paperwork from probation. You would file that paperwork and serve a copy of it on the prosecuting attorney's office and a copy to your probation office. The prosecuting attorney has 14 days from receipt of that notice to file any written objections to your request for early discharge. the probation department can make their own request for you to be discharged early. If they do so, they would file a copy with the court, and they will also send a copy to the prosecuting attorney's office. The prosecuting attorney again has 14 days to respond in writing with any written objections to that request, okay?
Yes, Your Honor.
If the matter is set for a hearing to address the request, you do have the right to hire an attorney to represent you for that hearing, but you don't have the right to court-appointed counsel for a hearing on early discharge from probation, okay?
Yes, Your Honor.
Do you have any questions about those rights?
No, Your Honor.
Okay. As to file number 23-03301, the court will credit you time served. Once you are released from custody, you need to report in person to our probation department. So I'm expecting you, I'm assuming you're not being held on anything else. I'm expecting you to appear in person to probation to check in, to make sure they have valid contact information for you, and that you're going to do that no later than Monday at 3 p.m., okay?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
Can you confirm your address for me?
The city rescue mission?
Yes, where are you gonna be staying?
I don't know the address of the mission.
You're gonna be at the city rescue mission, you said?
Yes, Your Honor.
Okay. Any additional matters for the record, counsel?
Nothing for the people.
I have nothing additional on behalf of Mr. Speed, Your Honor. Thank you.
Thank you. Good luck to you, Mr. Speed.
Thank you, Your Honor.
You're welcome.
Have a good day, Judge.
All right,
Same to
Jerry.
you. Have a good weekend.
All right, let's start.
Okay, so I don't see anybody present for Don LaChance.
Your attorney on behalf of plaintiff in that case.
Okay, on the record in the matter of people, I'm sorry, let me switch my brain over. On the record in the matter of Credit Acceptance Corporation versus Don LaChance, and this is file number 2200495. Let's see here. States here, the defendant did file bankruptcy and order was put and judge signed. Let's see, a hearing may still be required at bankruptcy order does not release garnishment. That was just a note from our civil department. I'm assuming that I would have signed that because I think this note was from the 18th. The defendant who's failed to appear today filed an objection to garnishment and notice of hearing indicating that they have filed bankruptcy proceedings. As a way of objection to garnishment. And this was an income tax garnishment, correct?
Yes, Your Honor.
They failed to appear, but the court otherwise finds their objections to be invalid. And so I will deny their objection. And any funds that are held will be released to plaintiff's attorney.
Okay, and I believe it also filed an administrative closing due to the stay of bankruptcy. Has that been signed yet?
If it was on base, it was signed unless it came yesterday. I haven't signed anything today yet.
Okay, because that was filed a couple of weeks ago and we've been calling for updates about whether or not it was signed, and I don't believe it has been.
Everything in my queue has been signed unless it was received yesterday.
Okay, would you like us to resubmit it then?
I don't need you to resubmit it because if it was submitted and it was signed, I don't see why you would need to resubmit it.
Because we don't have a signed copy back. Okay, so you would have sent the signed copy back is what you're saying.
This is signed. I see it in the file. Yeah, we see it signed in our file, so you can follow up with the civil department and make sure a copy was sent out to your attention.
Okay, thank you very much. I appreciate it, Judge.
Thank you. You're all set.
Thank you.
Okay, that's done, and that one's done. On the record in the matter of Discovery Bank versus Gregory Young. Sorry, Discover Bank versus Gregory Young, file number 23-02005 GC, council appearance.
May it please the court, Your Honor, Jeffrey Beers, P 41693 on behalf of plaintiff Discover Bank.
Okay, and no one is present on behalf of Gregory Young. This was a motion for summary disposition that was filed by your office. We've not received a responsive motion from Mr. Young nor his appearance today. So your motion will be granted by default.
Thank you, Your Honor. There should be a proposed order that we submitted.
Was that attached to your motion or was it submitted through my file?
I'm not sure.
Let me see if I see one here.
I think we'll probably have to e-file it, which we will.
Yeah, I see a whole lot of attachments here. But I don't necessarily see a order. So if you can submit one through my file, I will review and sign it.
I will do so. The dollar amount is $21,500.68, which represents damages of $21,221.04, court costs of $279.64, for a total amount of $21,500.68, and we will e-file a proposed order.
Very good. Thank you so much.
Thank you.
Any
Have a good
additional
day.
matters for the record?
No, nothing further, Your Honor. Thank you.
Thank you. On the record, in the matter of South Washington Park versus Tamika Martin, file number 23-02402, council appearance.
Good afternoon, Your Honor. Jeff Klug appearing on behalf of plaintiff South Washington Park.
Okay, Mr. Klug, today was the date set for a motion to stop eviction. The matter was scheduled for 2:30. It's 2:51. No one's appeared on behalf of Tamika Martin. She has filed this motion alleging that she had receipts providing proof of paid judgment. Let's see. It said that she paid all her fees from the judgment, and they're changing or charging me additional late fees while I was on a payment plan from November 15th. I don't think that it's fair. I can't afford the addition late fees. I'm low income. But I believe this is supposed to say, but all my court fee and rent is paid, and I'm willing to pay whatever else I have to. I was denied my Section 8 due to these fines. I'm just trying to pay what I owe and get my Section 8 back. And the matter was scheduled, and a notice was mailed to the address on file. It did return to us insufficient address for some reason. And I'm trying to understand why. Probably because they didn't put the correct, they didn't put an apartment number on. So she was not properly notified of the court date. So I need to reset this.
Yeah, I see that her apartment number isn't on the motion which she filled out. I did file a response. I know that's in the with the court, so we'll just wait for the next hearing date, Judge.
You're gonna set it in some.
I can set it. I just want to make sure we have it.
She's apartment 518.
Yes, that's correct.
May 13th at 2 p.m.
Thank you, Judge. Via Zoom again.
Yep, Zoom is fine.
Thank you. Have a good weekend.
Same to you.